सलामे मरकज़ इल्म व हुनर, गंजेर गंजेर नालो गोहर। अस्सलामे मरकज़ इल्म व हुनर, गंजेर गंजेर नालो गोहर। तेरे साए में हमारा नौजवान, तेरे साए में हमारा नौजवान। ऐन अगलब है कि झूले आसमान, ऐन अगलब है कि झूले आसमान। अस्सलामे मस्कने कर्ज़े जदीद, जहलो हमसे तुझे नफरत शदीद। अस्सलामे मस्कने कर्ज़े जदीद, जहलो हमसे तुझे नफरत शदीद। हर कोई गोशा तेरा बैतुल फला, हासिले इल्मे जदीद हरदम रवा। हर कोई गोशा तेरा बैतुल फला, हासिले इल्मे जदीद हरदम रवा। अस्सलामे मरकज़ इल्म व हुनर, गंजेर गंजेर नालो गोहर। अस्सलामे मरकज़ इल्म व हुनर, गंजेर गंजेर नालो गोहर। निगहबानी कर तू इन माल का, निगहबानी कर तू इन माल का। हाल का इस्लाह अहवाल का, हाल का इस्लाह अहवाल का। तालिबाने इल्म तेरे आर पार, याद तेरी इनको आती बार बार। तालिबाने इल्म तेरे आर पार, याद तेरी इनको आती बार बार। रहमतें हैं आम तेरी बेशुमार, मिस्दरे नौरोज़ आलम नौबहार। रहमतें हैं आम तेरी बेशुमार, मिस्दरे नौरोज़ आलम नौबहार। हर कसे नाशाद को अब शाद कर, गुलशने कश्मीर को आबाद कर। गुलशने कश्मीर को आबाद कर, गुलशने कश्मीर को आबाद।
Humayun sir, are you there?
Yeah, I'm here.
We'll start in a while. 2 minutes maybe. Okay.
Okay, no.
Humayun sir, you can start.
Okay. Uh, Uh, Good afternoon and assalamu alaikum, everyone. So this is the continuation of uh, our webinar series under the Ages of Viksit Bharat. Today we have our guest, Dr. Uwais, and he'll be delivering his talk on intellectual property rights and technology transfer, bridging innovation with legal protection. Before we begin the talk, I would like to welcome our staff secretary and our skill director of the college, Professor Tariq Ahmed Chalku Saab, and he'll be speaking, giving us a brief introduction on innovation and incubation, and he will also be talking about the current situation regarding innovation and incubation in the college. Over to you, Professor Tariq Ahmed Chalku Saab.
Chalku sir is here to join. You may ask the principal sir to kindly welcome our speaker and our participants.
Okay, thank you. So I would like our principal, our worthy principal, Professor Farooq Ahmed Rathir Saab, to formally welcome our guest speaker of the day, Dr. Said Uwais. Principal Saab.
हो गया Very good morning to all of you. Welcome, Dr. Uwais. I hope this program is going to be very interesting and, of course, beneficial to those who are innovators, who believe creativity, and who have got capacity to do something out of box. Because when we talk about intellectual property, it is not that property what we generally could talk about, the material property. It is the property that develops because of intelligence and how you are.
I think we have some disruption. We'll resume in a while.
नहीं बाहर का सहवाज जाम अभी यार नहीं नहीं
Humayun sir, are you there? Hello? Am I audible?
Yes, sir, you are audible.
Okay.
Okay. I'm sorry, there is some problem with the system. I welcome Dr. Uwais. What I was talking about the intellectual property, because nowadays world is progressing at a very rapid rate in the form of creativity, in the form of innovation and designing new things, and that too in the form of even space exploration. Whatever the minor innovation that we are going to take place, everything must get the person must get benefited. For that matter, the intellectual property right is a must, and we must be aware about it. Sometimes what is happening, a person is doing something and somebody else is taking benefit out of it. So for that matter, I think Dr. Uwais is the right person. I welcome him, and I hope that you are going to elaborate it, and whatever the questions that will be raised by the participants, please cooperate in that. Thank you very much, and you are welcome.
Thank you, sir.
Humayun sir, are you there?
Should I start?
Yes.
Just a second, sir. Just a second.
Okay, sure,
Humayun
sure,
sir has joined back.
sure.
Humayun sir, are you there?
So, sir, for such kind words, I would. Am I audible?
Yes, sir.
Okay, thank you, thank you. Okay.
I'm sorry, we have some disruption in network here. Kindly bear with us for 1 minute, maybe. Humayun sir, are you there? Yes, Humayun sir.
Should I start?
Yes, yes, kindly start.
So, I would like to introduce our guest for the day. I'm sorry for the disruption. Dr. Said Uwais. He completed his master's and PhD from Jamia Hamdard. Moreover, he has 20 research papers. Completed his LLB from CCSU. He is qualified Indian Patent Agent Examination. He qualified Indian Patent Examination with AIRS 5. Before joining higher education, he was working as a patent attorney in KNS Partners, which is one of the leading IP firms in India. Besides, he has drafted a number of patent applications for various research labs like RAD, CSIR, and IPER. He represented a number of national and international clients like NCL, BASF, etc. Our speaker of the day is highly qualified to speak on the topic that is intellectual property rights and technology transfer, bridging innovation with legal protection. I would like to, I would hand over the section to Dr. Syed Uwais to speak about on the topic.
Thank you, Dr. Himayu, for kind and generous introduction. I'll share my screen first. Hello. Am I audible?
मैं ये अपने रूम में ही हूँ आइए आ जाओ फिर
Uwais sir, just before, sorry for the interruption, just before we
Yeah.
begin the session, we have been joined by our HOD Physics and Staff Secretary of Government Degree College, Baramulla, ये Professor Tariq Ahmad Chalku sir.
Okay.
Sir is also heading the skill development the department here in the college. So I would like him to first address our participants about the achievements of this college in innovation and incubation. Tariq sir, are you there?
Yeah, I am there, but you need to I'm not able to start my video.
Yeah, sure. I'll.
It seems that the host has the control over it.
No problem, sir. Just a
So
second.
if you can
Is it okay now, sir?
just a sec, let me open the video. Yeah. Very good afternoon and salam to all of you. I am glad to see the galaxy of intellectuals and participants from all across the colleges of Kashmir Division and others. And so pleased to see you on such a cold afternoon, but somehow taking up a topic of great importance, because what I feel is that the higher education is taking now a very serious turn towards NEP, and the differential of the previous things which we have been doing in the colleges and schools and the new paradigm which has come up, one of the differentials is skill development and innovation and incubation. Earlier, it was left to the efforts of an individual that if he could do it, and it was quite optional for us to trudge the path. But now somehow it has become mandatory for the institutions. Like our college is a part of one institution, Incubation and Innovation Council. We have a full-fledged vertical on this part of the activity in our college. And somehow, to tell you very honestly, that since the old mindset prevails, we might not have earned very great mileage on this path. And that's why I find that today's session for this college and other colleges of the like must be treated very, very important. I am glad to see Dr. Syed Uwais as the expert on the topic, and he will be definitely delivering a very enlightening session, which will be a guiding path for all of us. The disruptive interventions at the hands of the scholastic people like our students and us is a very serious need of the hour. We should not always look at West for innovation or incubation and the inventions. We have to start, and the programs like Make in India, then the programs like the government is highly into the important competitions, starting from the school level itself, that this place has to become the place where the buck ends for the school children and for the undergraduates. And there, I wish this session becomes something, a very breakthrough session for the whole program. And I'm glad to congratulate once more Dr. Akib for this heading this Convergence 360 program. And this is, I believe, the fourth session on this. Thank you from my side, and please go ahead. Thank you.
Now, Dr. Uwais, please start your talk.
I hope my presentation is visible.
Yes, sir, it is visible.
Thank you, sir. Respected Principal of GDC Baramulla, Professor Dr. Muhammad Farooq Rathar, sir, HOD Physics, Professor Tariq Ahmad Chalku, sir, Coordinator IQAC, Dr. Saeed Mutahir Akib, distinguished faculty members, participants, Assalamu alaikum and good afternoon all. At the outset, I would like to thank Dr. Saeed Mutahir Aqib, who invited me for this talk on IP, though I am a student of it. So, as you all know that this webinar series is being conducted under the aegis of Viksit Bharat. Therefore, as academicians, researchers, we have to contribute to it. As researchers, we can invent, we can innovate, and protect those innovations under various laws of IP, and then transfer the technology, transfer the knowledge to the stakeholders. This will not only benefit us, this will benefit society at large, our university, society at large, and then ultimately it will make India as a developed nation, which we call as Viksit Bharat. As you might know that USA, China, they are the leading IP holders in the world, because they are the developed nations and they actually invent the things for which they are on top of IP filing. So without wasting much time, I'll start my presentation, that's intellectual property rights and technology transfer, bridging innovation with legal protection. So there are two parts of my presentation. First, I'll be giving you the IPR overview, different type of IPRs, law that govern those IPRs. And then in the next part, there will be technology transfer, why we need to transfer the technology. So let me go into the history. Intellectual property right, it all started in 14th century in Europe, when the first patent was granted to a person. He was an engineer, Filipino was the name of that person, and it was some kind of barge with hoisting gears. It was used to carry the marble, and the patent was granted for 3 years. The monopoly was for 3 years. And the important thing here is that it was granted in 14th century. And we people are still thinking that should we go for filing a patent or any other intellectual property? We are still in the infancy. So this intellectual property rights, these are legal rights that are being given to the inventor or the creator. And these rights are time bound. And these rights play an important role. This IP plays an important role in modern economy. So if we go by the definition, the broadest and the most appropriate definition is given by World Intellectual Property Organization, which we call as WIPO. The definition is, it is the rights related to literary, artistic, and scientific work, or a rights related to performance, performing artist, phonograms, broadcasts, any invention in the field of human endeavor, or scientific discovery, or industrial design, or trademark, service marks. All the rights related to these works, these inventions, are protected by the intellectual property rights. They are being protected from the unfair competition. Because if I, for example, invent something, if I invent this pen, I have put in my money, I have put in my heart and soul, I have put in my everything to invent this pen. And now when I come to the market, there should be no unfair competition. Just because I should get something out of it. I should get some royalty out of it. I should get a name and fame out of it. Therefore, in order to protect those rights, intellectual property rights govern all these properties. So what exactly intellectual property is? It is a creation of human mind, creation of intellect. It's an intangible property, like your house, your car is a tangible property, which you can touch, you can feel. It's an intangible property. And trust me, if this property can be much more valuable than your tangible properties. These are exclusive rights given by the statutes. Whenever there is right, there are limitations and there are exceptions. Here also there are exceptions as well as limitations, which we will be discussing in next few slides. These are time bound. You are being given monopoly, but it will be time bound. For example, in case of patents, it will be 20 years, sorry. So it is not like you get the rights for eternity. No, it will be time bound. It will be territorial. For example, if I have invented something, let me take this example of this pen. If I have invented this pen in India, if I file a patent application in India, I'll get protection in India only. There will be no protection in Bangladesh, Pakistan, US, until and unless I file an application over there and the patent is granted there as well. So it is an the intellectual property right. It is a contract between creator and the sovereign state. For example, if I have invented something, or if I'm an innovator of something, I am the creator, and my state is the state in which I filed the application. If I file in India, then the IP Act of India will come into play, and I'll be given some kind of rights. I am being protected because I put my invention in front. I place my invention in public. So there should be balance between the creator rights of the creator and rights of the public. So which will be discussed. This point will be discussing in patents. And as I already told you that with rights, there come limitations, there come exceptions. So intellectual property rights are being classified into two groups usually. First is copyright and related rights. The second one is industrial property. Industrial property further consists of patents, industrial designs, trademark, geographical indications, layout, design, topographical integrated circuits, trade secrets, protection of new plant varieties. These are the different acts which govern these intellectual properties. For example, if you have written a book and when you file a copyright for it, it will be governed by the Copyright Act 1957. Similarly, if you have invented something and you file a patent, it will be governed by by the Patent Act 1970. For design, there is a Design Act. For trademark, there is a Trademark Act 1999. Similarly, for geographical indications, there is Geographical Indication of Goods Act 1999. For the semiconductors, integrated circuit layout designs, there is an act. Similarly, for the plant protection, there is an act of the Protection of Plant Varieties and Farmers Act. We'll be discussing these major intellectual properties one by one. First is copyright. This is the sign of copyright. Wherever you see this kind of sign, you should come to know that this work is being protected under the Copyright Act. So what's copyright actually? Indian Copyright Act Section 14 explains what exactly copyright is. It is a rights related to original literary. It must be original. Literary work, dramatic, musical, artistic work, cinematographic films, and sound recordings. Rights related to these three groups of works will be protected under the Copyright Act. For example, it is the work which is being protected, not the idea. What does that mean? For example, in my mind, I am clear that I will write a book on, for example, genomics. Everything is clear in my mind, what I have to write, which experiments I will put into that book. But that's an idea. I won't get a copyright for that idea until and unless I put that idea in the form of a book. Similarly, I'll give a simple example. A few years back, maybe 30, 40 years back, a person thought that I'll get singers from all over India and let them sing on the national television. And there will be judges and there will be an audience which will vote and there will be a winner. This was his idea. If this idea could have been copyrightable, then all the singing competition shows, be it Saregama, be it Indian Idol or any other show, would belong to that person. But no, when he put that idea in the form of Saregama, the Saregama show has copyright. Similarly, when that idea was expressed in the form of Indian Idol, that got the copyright. So it is the idea which it is the work which gets the copyright and not the idea. There are always two kinds of rights that are protected under the Copyright Act. First is moral right, second is economic right. What's economic right? For example, I wrote a book, I'll give it to some publisher and we'll have a deal. We'll have a deal that he will give me this much of royalty. That's my economic right. But at the same time, I have moral right. What does moral right mean? He cannot mutilate my work. He cannot add himself as an author to that work. He cannot delete or add to that work because that's my moral right. So with whom rights will lie? In case of literary work, it will lie with the author. In case of drama, it will lie with the dramatist. In case of music, it will lie with the composer. In case of artistic work, it will lie with the artist. In case of photograph, it will lie with the photographer. Similarly, computer program, it will be the programmer. Cinematography films, it will lie with the producer. Sound recordings, it will lie with the producer. So how long is the duration that the work will be protected under Copyright Act? In case of literary, dramatic, musical, and artistic work, it will be lifetime of the author plus 60 years. For example, if I have written a book, it will be my lifetime. Then the day I go from this world, and you have to count 60 years from that day. In case of sound recordings, that's cinema, it will be 60 years from the publication. There is no lifetime this thing. In case of posthumous publication, if the author has already died and then you have published the book, it will be 60 years from the date of publication. Pseudonymous work, it will be 60 years. For example, if somebody is writing a book, I don't want my name in that as an author. I'll put author Mr. X. Nobody knows who is Mr. X. In that case, it will be 60 years from the date of publication. Anonymous work, you don't know exactly who has written the book, then it will be the 60 years. But in any case, in between those 60 years, if you'll come to know that this book was written by Saeed Uwais, in that case, it will be lifetime of Saeed Uwais plus 60 years. For work of government and organizations, it will be the 60 years. So there was one case law which is very important with respect to our, because we belong to higher education, it's very important with respect to our profession. There was a case law in which Cambridge Press, Taylor Francis, Oxford University, they filed a case against Rameshwari Photostat and Delhi University. What was the case? The case was that Rameshwari Photostat, which is one of the photostat in the North Campus of DU, he used it to copy the books, photocopy the books, and then sell those photocopies. So Delhi High Court said, you are infringing the copyrightable work. Don't copy the whole books, and he had to pay some money as well to those publishers. And at the same time, court said that if you photocopy some portion of the book for your personal use, that's fine. But you cannot photocopy whole book and then go on selling it. There is one more case. It was Paramount filed Paramount Pictures from Hollywood film industry filed or they sent a notice to CCSU, Chaudhry Charan Singh University. What happened? Chaudhry Charan Singh University gave an free internet on their campus, in the hostels and in the campus. The students starting downloading the films. They downloaded it in such a quantity that Paramount had to come and send notice to CCSU that you are infringing our copyrightable things. So don't do it. Otherwise, we will file a case against you. We'll sue you. So this is the trend of filing of copyright. You can see that the trend is being increased from 1819 to 1922 and 2021, which is the latest data which I have. The trend, this is how it goes on. So since different kinds of works can be protected under copyright, you can see the most number of work that has been filed is literary dramatic work. 514 applications were granted in 2021, followed by the artistic work and the rest of the works. Now there is one more thing before I go to the next intellectual property, right? You don't have to, if you write a book, you don't have to file a copyright before the Controller General of Patents and Copyright and Trademarks, because if you mention C with the circle, that means it is it's your work. Nobody can use that work, but it is easy to prove in the court of law tomorrow if you have already filed this copyright, filed copyright, and it is granted to you. Otherwise, in any case, if you do not file, still the copyright lies with you. The next is trademark. So this is the symbol of the trademark, EM within the circle. What's trademark actually definition is? Section 2ZB of Indian Trademark Act says any mark which can be represented graphically. It can be anything. It can be a sign. It can be bird. It can be letter. It can be number, a drawing, picture, emblem, anything, combination of colors. If it represents your business, if it represents your services, then you can say that this is my trademark. For example, Lux is one of the trademarks. Godrej is a trademark. TVS, this wool mark. When you go to the market to buy cloths because the winter season is going on, you check whether there is a wool mark or not, because this trademark has already shown that this is the best wool that is present in the market is wool having this sign. Similarly, we have Godrej, we have Amazon. These are all the trademarks. So in case of trademark, you have to file in, for example, if I start a new business and I keep some name to it, for example, Saeed Uwais Associates or whatever, then I file a trademark. I have to file it before the Control General of Patents and Trademark, which is the office is in Delhi. I'll file the application. It will be examined under the Trademark Act. If it is abiding all the laws of Trademark Act, I'll be granted, after examination, I'll be granted the trademark. And trademark will be for 10 years. After 10 years, I have to renew it. And I can renew it till indefinite times. After 10 years, I'll pay a fee. It will be renewed for another 10 years and so on. Kinds of trademark. Trademarks, there are a number of trademarks. For example, marks on the goods. You check on your shoes, you check whether the Nike tick is there or not, whether the Adidas flower is there or not. These are all the marks on the goods. Service marks. If there is some kind of service is being provided, you check if certain service mark is there or not. Certification mark. For example, we go to buy some electrical appliances. We check whether ISI mark is there or not, because ISI mark is a certification mark. Similarly, there is we call it as collective mark. For example, Sony, the collective mark. Under Sony, we have Sony Bravia, we have Sony Xperia, but Sony itself is a collective mark. Well-known marks, for example, Coca-Cola is well-known mark, Pepsi is well-known mark. Trade names, for example, I have there is some trade going on, and that name of the trade is Saeed Uwais Traders. That's a trade name. These are some well-known marks. For well-known marks, you have to pay extra to the Control General of Patents and Trademark so as to be protected. For example, Coca-Cola is a well-known trademark. Toblerone, that's a triangular shaped chocolate. That's a well-known trademark. Godrej furniture, refrigerator, GE, that's a well-known trademark. So what is not protected? Always law tells us what it does not, what not to do. Law never tells us what to do. So anything which hurts the religious sentiment, if I create some kind of mark, but it hurts some kind of religious sentiments, it will never be granted by the Control General of Patents and Trademark. If that mark is scandalous and obscene, that will not be granted. Similarly, state emblem, Ashoka Chakra leke jayega, to it will not be granted to him. Similarly, official hallmark, these or the marks of governmental organizations, these will not be granted. There was one case in, I guess in 22-23, this case came to the limelight, where Starbucks filed a case against Sardar Baksh Coffee. This is the Starbucks logo of Starbucks. This is Sardar Baksh Coffee logo. The name deceives the people. Starbucks, Sardar Baksh. Plus, the logo also is deceivable. So what Starbucks did, this Sardar Baksh opened, I guess, more than around 100 coffee shops in one day. It inaugurated. So what Starbucks did, Starbucks filed a case, I guess, in Delhi High Court, and they said that, this defendant, he is infringing our copyright name as well as our logo. And later on, the infringement was granted, and this court told Sardar Baksh, you should change your name from Sardar Baksh Coffee to Sardarji Baksh Coffee. And logo was also changed. There was one more case in which Wattman International filed a case against P.S. Mehta. P.S. Mehta was doing a business. He's from Delhi, and he was making these Wattman filter papers. And for 25 years, Wattman International said nothing. After 25 years of his business, they filed a case, and he had to give this money to them. I guess the penalty was around 40 crores he has to pay to the watchman. So whenever we start any business, any venture, we should look into these things, because you never, at this point in time, your business might not be flourishing, but when it will flourish, when it will come to the internet world, when it will come to the company whom you are infringing, they'll come and sue you and will take your wealth and as well as name. Like in this case, Honda Motors filed a case against Charanjit Singh. What Charanjit Singh did, he started making pressure cookers in which we cook the food, and the name of the pressure cookers he kept Honda. And people started thinking that the Honda from Japan, which was into the automobile business, now they are making these pressure cookers as well. And people were buying it like anything. The Honda ka pressure cooker aa gaya. And Honda filed a case before the Delhi High Court, and Delhi High Court said it is creating deception, confusion in the minds of public at large. So he had to pay the penalty to the Honda Motors, and the court said you have to change your name. So this is the trend in trademark filing. You can see the trend is increasing. Similarly, these are the applications. They are being examined by the Indian General Control of Patents and Trademark, and these are the applications that are being granted in the year 2018 to 2021. If we talk about state-wise, Maharashtra is #1 in filing the applications, followed by Delhi, followed by Gujarat, and J&K is not in the picture. Similarly, as in the beginning of this presentation, I said that US and China being developed, they are #1 or #2 in filing any patent, any kind of IP applications, being patent, being trademark, being copyright. Here you can see United States is #1, followed by China, followed by Singapore. This is the filing in India. This data is filing of US in India, filing of China in India. So the next is industrial design. Any design, as per Section 2D of Industrial Design Act 2000, any shape, configuration, pattern that can be shown visually, having 2-dimensional or 3-dimensional form, can be filed in the Industrial Design Act, can be if examined and found suitable, it can be granted. The examination will be done solely by the eye. That is, there will be no technicality involved in it. If the design is new, it is not, for example, I created new kind of sofa. There is a new design, new kind of chair, new design chair, I say. If the design is new, irrespective it is comfortable or not, that won't matter. If it is new, design is new, it will be granted. No technicality is involved in that. Why I'm telling this, I'll tell you in the next slide. These are some, for example, the design of the press, design of Kolhapuri chappal, design of this bottle. These are all protected under the Design Act. Similarly, we have design of dispenser, design of injection, design of injection. These are all protected under the pharmaceutical product. Similarly, we have a design of jewelry, and you go to the any jeweler and you buy some kind of ornament. Nobody can copy it, because it might be his trademark, and you copy it. See, if you copy one piece, no, there is no problem. But if you copy in hundreds and thousands, and they'll come to know, they'll come and sue you. So why I was telling to that there is no technicality involved, because in US they grant you design patents. In India we don't have design patents. In India we have industrial design. If in India your design has some kind of technicality, then you will file a patent for that. You don't need to, you can file a design as well as patent. But in US there is a design patent. You can file a design patent. In that case, your design should be new, as well as there should be technicality involved in it. So when you file a design application, if the application is granted, it will be granted for 10 years. And after that, it is extendable to 5 years. That means total protection will be the 15 years. After 15 years, it will be open to the public and anybody can use that design. What's not registrable? Any design which is not new. If you copy a design, that is, it is not new, there is no novelty, it will not be granted. If it is disclosed anywhere in the public, it will not be granted. If it is not distinguishable from the counterparts, if I have designed some kind of bottle, if it is not distinguishable, there is a deception, there is a confusion between the already known design and the new design, it will not be granted. If it is scandalous, it is obscene, then it will not be granted. If it is against the public order morality, it will not be granted. This is a case of 2022, wherein you might have seen these kind of bulbs in the market. The first, this T-shaped bulb was given by Signify. Signify is the subsidiary of Philips, this T-shaped bulb. After that, Jai Product and Syska, they just did some minor modification in design and then came to the market with these bulbs. But when this Jai, Signify or Philips sued them before the Delhi High Court said that mere there is a deception, and mere just changing the minor change, it won't help. So you cannot, their design was not registrable. This is the trend in filing of design applications. See, this is increasing from 2018 to 2021. These are the number of applications that were examined, and this is the number of applications that were granted. In design application, when we talk about our own states, Gujarat is number one, maybe because they are more into the jewelry, followed by Maharashtra, followed by Delhi, and still we are not in the top 10. And these are the foreign filing applications in India, and you can see that USA is number one, followed by China, then Japan, and so on. Next intellectual property which we are going to discuss is geographical indications. According to Section 21E of Geographical Indication Act, any product, be it agriculture, be it natural, be it manufactured, which is being originated or manufactured in certain part of the country, by that certain part of country, I mean to say that some kind of quality, some kind of reputation will come into that product. If it is the case, then a geographical indication will be granted. For example, recently we had a geographical indication of Mushko Buduj. Mushko Buduj is a kind of this chawal, rice we have. Because due to certain territorial territory, because due to certain because of that region, some kind of quality, some kind of quality will come into that product, and that's why that was protected under the GI Act. Why GI Act was necessary, and it was recently in 1999 the Act was passed, and 2003 the Act actually came into the play very recently. This is because there were three controversial cases. First one was with neem, second one was with turmeric, third one was with basmati. I'll give you a brief about these cases. Neem, there was one company in US, WR Grace, I guess. So they filed a patent application, method of controlling fungi. In that patent application, they disclosed that neem plant can control the growth of fungi. When India came to know that a patent has been granted for the neem being as an antifungal compound or antifungal entity, they went to USPTO and they went to the European Patent Organization, EPO, and they filed an opposition. They said that the neem, we know it is our traditional knowledge. We have been known from the centuries that neem is antifungal. So you cannot grant a patent application to that. Later on in year 2000, the patent was revoked. When patent is granted, if it is then cancelled, we say the patent is revoked. Before the grant of patent, if it is cancelled, we say that the patent was not granted. Second case was turmeric. Two NRIs from the India, they went to US, they started working on turmeric, and they filed a patent application that turmeric as a wound healer, a wound healing agent. When this patent application came to the market, and CSIR noted, and they opposed the patent in the USPTO. They got manuscripts from the Sanskrit. as well as they got manuscripts from the Tibi Nabbi that the turmeric is known as an wound healer. So you cannot grant the patent. And later on, the objection was upheld and the patent was revoked. Similarly, the third thing, that is basmati. Texas-based US rice company, they filed a patent application in USPTO that they had made some kind of new basmati, and that basmati was already known in India. Later on, the patent was not revoked. However, there were 20 claims. Out of 20, 15 claims were revoked. Only 5 claims were given to them. So, in order to prevent this exploitation, this kind of the competition, unfair competition, the Indian government passed an act, Geographical Indication and Goods Act 1999, which later came into the effect from September 2003. So the first GI tag was given to the Darjeeling tea. Since then, more than 300, I guess there are around 400 or 400 to 500 geographical indications are granted. Karnataka is number 1 in filing the geographical indications, followed by Tamil Nadu. Karnataka is 42, Tamil Nadu has 38 geographical indications. This is Kadaknath, a kind of chicken, which is actually found in Chhattisgarh. Recently, I came to know that from Pulwama side, they are also rearing these kind of chickens. But actual Kadaknath, original Kadaknath, which is high in the protein, that's why his eggs, his everything, his meat is black because of high proteinaceous content, is a geographical indication of Chhattisgarh. Before geographical indication, the price was 500, and later on, when it got the GI tag, the price jumped to 1,000 rupees. In J&K, we have more than 9 this geographical indications. It includes Kani Shal, Pashmina, Sozni craft, paper mache, walnut, wood carving, Khatamban talo. We have Kashmiri hand knitted carpets. We have saffron. And in year 2023, 5 new geographical indications were granted. The first one was saffron from the mountainous Kishtwar, the saffron of Kishtwar district. Earlier, it was saffron from Pampore district. Now, the Kishtwar district, they also got a patent. Badrua Rajma. Sorry, not patent, geographical indication. Sulai honey of Doda and Ramban. This is our new geographical indication. Rajori Chikri, woodcraft. This is our new. And Mushkubudush, which I already discussed, that these 5 things, these 5 entities got new geographical indications in year 2023. So this is the only intellectual property wherein it's not attributed to individual or to the university or to the company. It is given to the whole society. For example, if an NGO from Pampore or from District Pulwama, they filed an application before the Geographical Indication Office that the saffron of Pampore is has an characteristics, particular characteristics because of that land, because of that environment. So when geographical indication was granted, it was not granted to that person who has filed the application. It was not granted to that NGO who has filed the application. It was granted to the people at large. Anybody can use it, provided he is selling you the original thing. So the registration, first, it is valid up to 10 years. But after 10 years, you can renew it by paying the fee. And then you can renew it indefinitely after every 10 years. This is the geographical indication trend. So you can see that trend, it is increasing from 32 to 42 to 58 from the year 18 to 1920 to 2021. As I said, Karnataka is number 1 in filing the geographical indications, followed by Tamil Nadu. And there are other states still. We are not in the top 10. The next part of the presentation includes the patents. So every time I use this slide because this motivates the innovators. See, the ring which we pull on the Coca-Cola can or any other can these days, this was invented and the invention looked so simple. But the inventor gave this invention to the Coca-Cola and he earned 1,48,000, this amount from the Coca-Cola. Just a simple invention. But yes, there was a technology transfer. He invented it and he knew the stakeholder who will get it into the market and from whom I can get the royalty. So what are the patents? These it's an exclusive rights that are being granted to the inventor because he has invented something. He has put his money, he has put his time into that invention, he has put his intellect in that invention. Therefore, exclusive rights are granted to him, and exclusive rights are granted for 20 years. So these are negative rights. That is, it excludes the others. No other person can use these rights, this patent, till it is in the force for the 20 years. In India, we have patent for two things only. One is product, another is process. So we have patent for product and we have patent for process in India. In US and in EPO, European Patent Organization, you can have patent for use as well. In India, we don't give, for example, aspirin is also already known as an, for example, analgesic. I cannot say that new use of aspirin as an anti-cancer. Yes, that is not patentable in India. These are territorial rights. What does that mean? If I file a patent application in India, I'll have protection in India only. If I file a patent application in US, I will have patent application in US only. So these are territorial rights. Why do I file a patent? Because I have to claim ownership of my invention. There should be monopoly. Because I have invented something, if I cannot get that thing into the market, I will sell that, I will license that, I will transfer the technology to some other stakeholder, and I will take royalty from them. So why should I file a patent? Because it will encourage others to innovate. When I get something, get some royalty, get some name, fame, maybe some other will come out, and some other person, some other R&D will start where I ended. So who can file a patent? It either alone or jointly by the true and first inventor. The one who is the true and the first inventor, he can file the patent. In case true and first inventor doesn't file it, he may put some assignee, and that assignee can file the patent application. Or in case that the true and first inventor is deceased, then his legal representative can file the application. So we have 4 patent offices in India. We have it in Mumbai, we have it in Delhi, we have it in Kolkata, we have it in Chennai. But we cannot file the patent application anywhere we want to. But no, since we live in the J&K, we can file a patent application. Our designated office will be Delhi. Similarly, if somebody from Kolkata, he will file in Kolkata. If somebody is from Mumbai, who will define where we should file? It will be defined where the invention is being brought up. For example, I am from J&K, but I have done some invention in some lab in Kolkata. Then I cannot file it in Delhi. I'll have to file it in Kolkata. So, place of residence, which I discussed, that if I reside in J&K, but I have brought the invention in Kolkata, I'll have to file it there. So, what is patentable? Anything which is new, a new product or a new process. As I said, the patent will be granted for a product or the process only. See, claiming novelty, claiming that my product is new is not a big deal. If the two things are not mirror images of each other, we will say that they are novel with respect to each other. But novelty is easy, inventive step is not. Inventive step is you have to prove the technical advancement. You have to prove how you have technically advanced from the all already known information. You have to show that your invention is non-obvious. It's not obvious to a person who is skilled in the art. For example, I did some invention in chemistry. So it should not be obvious to a person, to somebody who is already from the chemistry. He should not say there was already one information and he has just molded that information and it was obvious. In that sense, it should not be that. And it should be it should have industrial application. What does that mean? Most of the times, not most of the times, many a times, we see that we do some kind of invention in the laboratory, but when we go for a scale up, there is a problem. It is not replicable at the industrial level. that invention would not be patentable. So it must have industrial application. So patent eligible subject matter. What is patentable? Section 3 and Section 4 says what is patentable in India. First, Section 4, it is the simple section. It says that anything which is related to atomic energy will not be patentable in India. It will lie with the state. You have to give it to the country. Section 3, there are 15 subsections which says what is not patentable in India. Section 3A says anything which is frivolous, contrary to the already known natural laws, that is not patentable in India. For example, you will say, I have invented a machine where we do not give any input, it will go output. Perpetual machine. That's not patentable because it's against the natural laws. So anything, Section 3B says anything which is contrary to the public order or morality or prejudice to the human, animal, or plant life will not be patentable. For example, I invented a gambling machine. I invented a method for committing theft. That will not be patentable. Although there might be novelty, there might be inventive, there might be non-obviousness, that it might have industrial application, but since it is prejudice to the human life, it is or animal or plant life, or it's against the public order or morality, then it will not be patentable. Section 3C says that mere formulation of abstract theory, what's already in the nature, you will rediscover it, will not be patentable. For example, there is already some compounds in the cerebrospinal fluid or cerebrospinal fluid. If I extract some kind of compound out of it, it will not be patentable because it was already in the nature. Yes, but the method by which I extracted it, if that method is original, if that method has novelty, inventive stuff, non-obviousness, and industrial application, that method will be patentable, not the compound, because compound was already there. Section 3D. This is one of the important sections which stops the patent evergreening in India. Since we are going to be Viksit in 2046, we are not yet developed. Therefore, this section is very important. There are 2-3 sections, 3D, 3F, which are very important with respect to our this country. Section 3D says that mere discovery of new form of known substance will not be patentable until you show efficacy. What does that mean? For example, the paracetamol is already there. It cures your headache and all those things. It's analgesic, for example. Now, tomorrow I'll come with the invention that I have made a new salt of paracetamol and I want to patent it. I can patent it only if it shows me the therapeutic efficacy. Only if it shows that it is more biologically active as compared to the already known substance. Let me come to this case, Novartis versus Union of India. This case went to the Supreme Court as well. The decision was given by the Supreme Court. It started from Patent Office. It went to the IPAB, Intellectual Property Appellate Board. It went to the High Court, and then it was settled in the Supreme Court of India. And Supreme Court of India said that what was case about? The case was about imatinib mesylate, the drug. And what Novartis did, they formed a new form of it, beta crystalline form. Chemistry people can or bio people can relate more to it. They form, it is new crystalline form, and they got patent in US, they got patent in EP, Europe. But when they came to the Indian government, Control of Patents, they rejected the patent. They said, and finally, Supreme Court said that it is patentable only if you show therapeutic efficacy. Therapeutic efficacy, that is, it is biologically more active as compared to already known, as compared to imatinib mesylate, which is already known. If it shows more therapeutic efficacy, then only it is patentable. Otherwise, it will not be patentable. So this section is important with respect to the evergreening of patents, which we say. As I earlier said, that there should be a balance between the already known, balance between the rights of inventor as well as the rights of the public. Section 3E, it says mere admixture. It will not be patentable unless and until it shows synergism. For example, I'll say that I'll mix 2 drugs. I'll mix paracetamol and ibuprofen. Paracetamol is known as antipyretic. Ibuprofen is known for analgesic. I'll mix the 2 drugs and then I'll come with a new drug and say that this is the drug, which is the combination of two. It is antipyretic as well as analgesic. What's invention in that? There is no invention in that, because I have just mixed the two drugs. But if these two drugs, paracetamol and ibuprofen, if they somehow synergistically, the quality of the ibuprofen will affect the characteristics of paracetamol, and that mixture of two will be anti-cancer, will form a new drug which is an anti-cancer drug. That is patentable because there will be a synergism. There was a case law between that was filed by Stumpeutics versus Assistant Control of Patents, wherein ITAB held that if the one of the two materials we have in composition, we can have more than two things, more than two components. If one of the components of that composition is novel, in that case, Section 3 is not applicable. Section 3F, it says mere arrangement, rearrangement will not be patentable. That is, for example, I have devised a new, what you call that, a new remote control. And in that remote control, what I did, usually what we did, हम remote की नीचे से battery निकालते हैं. मैंने नई invention की है, wherein the batteries are fixed from the upper side of the remote. That is mere arrangement, rearrangement of the known things. That will not be patentable in India. Similarly, 3H, this is also very important with respect to patent evergreening. Method of agriculture and horticulture, it's not patentable in India. It is patentable in Europe, US, as they are developed nations. But here, looking into the rights of farmers, it is not patentable. So I cannot patent a method for cultivation of algae. I cannot method of growing leguminous plants. I cannot get a patent for that. Section 3I, which is very important also with respect to patent evergreening, which says that a method or a medical, surgical, curative, diagnostic, therapeutic, any method which will render a person free from the disease or animal free from the disease will not be patentable. For example, in COVID times, method of vaccination was not patentable. However, vaccine itself was patentable, but its method was not patentable. Method of treating malignant tumor cells is not patentable, but a drug will be. Similarly, 3J, plants and animals, whole or any part will not be patentable. It will be protected under the Plant Varieties Act, but in here it will not be patentable. Mathematical business development program or computer program will not be patentable. Computer program can be patented under the Copyright Act, but patent will not be granted for it. Similarly, literary, dramatic, musical, artistic work, you cannot get the patent for it. You have to file copyright. I'll give you one example. A year before, I met a person from J&K. He told me that he is working on some musical notes which are used to cure the brain disease, and he wanted to file a patent. He might get a patent in US or EP, but in India, it's not possible, because in India you have to get the copyright, or patent will not be granted. Similarly, Section 3M says a mere scheme or method of playing or mental act, जिसको हम जादूगरी बोलते हैं, या method of playing game, they are not patentable. A presentation of information is not patentable. Topography of integrated circuits is not patentable. However, you can have protection under the Semiconductor Topography Integrated Circuit Act. Similarly, traditional knowledge, which we earlier discussed, that neem, or we discussed about this basmati rice, different kinds of basmati rice, or we discussed turmeric. They are all our traditional knowledge. They are protected under the Traditional Knowledge Act, so they are not patentable in India. This is a trend of filing the patent applications. Maharashtra is number 1, followed by Tamil Nadu, followed by Karnataka. Still, we are not in the top 10. And with respect to countries, as I said, China and US are always competing. China is at number 1. They have filed 69,540 patent applications in year 2021 in India only. Leave rest of the world. US has filed 59,570 patent applications in India only. So now I'll come to the common mistakes that are being made by the scientists, that are being made by the researchers while they do the research. First mistake they do not keep their invention secret. They go on discussing their invention here and there. And trust me, when you file a patent application, the biggest prior art is the inventor himself. How? He might have discussed it somewhere. He might have made a poster of that that invention and presented it somewhere. He might have published a research paper out of it. So you have to keep your invention secret until the date of filing. Once you have filed, if you have filed today, before noon, after noon, you can do anything with your invention. Prior art search. Earlier, the prior art search was very tedious. You had to go to the libraries and all those. Now it is on single click. So you have to search that maybe somebody has already done some kind of work on it. 25% of R&D efforts go wasted because prior art search is not done properly. This we have already discussed that, discussing the invention in public. Invention is not new. There is no novelty. There is no inventive stuff. There is no obviousness in the invention. For example, wheel is already there. Reinventing wheel will not help. However, if you reinvent wheel with the technical advancement, then it may be patentable. Invention is too complex, which I already said that you can do it on your lab, on milligram scale, in your lab. But when we go for the scale up, there are problems because the invention is too complex. In that case, there is no industrial application. Then the patent may not be granted. Obviousness. There should not be obviousness. It should not be the obvious to a person skilled in the art. For example, I am from chemistry. If I do some kind of invention, it should not be obvious to any other person, to any other chemist who is working in the same field. Half-baked inventions. This is one of the biggest problem we have. बंदे का PhD खत्म हो गया, उसने छोड़ दी research. That is a half-baked invention, and you go on filing a patent application. This will not be granted because there is lack of data. No commercial utility in this application. There should be commercial utility. For example, in this case, he says that I have invented glasses. Trouble is that I cannot see a thing. It's the opaque glasses bana diye. So no commercial utility. There will be no patent application for that. This is one of the biggest problems that we keep on delaying. Procrastination. We keep on delaying filing. Chalo, aaj karunga, kal karunga, aaj ye ho gaya, kal wo ho gaya. So we keep on delaying. Underestimating your invention. You should never underestimate your invention because it is you who has invented it. You know in and out of your invention. It might look simple to you, but trust me, it is not as simple as you think. Because when you go to the market, it might have tremendous utility. For example, nut and bolt. There was a US patent on it, on nut and bolt. The U-clip that you used in the paper. There was a patent in 1901. There was a patent. Sorry, in 1897 there was a patent for it. In this tissue roll, which is being perforated, this perforation, this tissue roll, there was a patent for it. Volvo filed this patent application, and patent was granted for 3-point belt system, which we use in our cars. Later on, they gave up the patent. They could have earned billions of dollars, but they gave up the patent just for the sake of public at good. They say anybody can use it. That 3-point belt system which we use in our cars. So don't wait for the perfect invention. If you feel that you have done some kind of work, go and file, review it and file the patent application. If you feel like that there is another lab which is also working on the same field and they might go forward, they might pass you, then in that case you file a provisional application. And filing provisional application means you don't have complete data. From the date of filing of provisional application, you will have 1 year to file the complete patent application. This is very important. You have to maintain your lab records with signed lab records. When in our labs, we don't usually do it, but in CSR labs, they do it. And in R&Ds, this is of utmost importance. There is a regular check whether GLP is being following, and there's a regular check whether the lab records are being maintained and signed. Every day you come, You have to mention which experiment you have done, the quantity of the things that you have used in that experiment, and you get it signed by yourself and by your supervisor as well. Because you never know when you need all those things. See, in case of papers, we usually see that paper किसी ने काम किया था and somebody else got it published. There is no much legality involved, but here legality is involved. You have to check who is the true and the first inventor. You have to check who is the applicant. For example, in GDC Baramulla, if GDC Baramulla is giving me a lab, GDC Baramulla is giving me some project, funding me, when I will file a patent application, GDC Baramulla will be the applicant. I will be the true and first inventor. But all the legality will be done with the GDC Baramulla. There are some labs, for example, BHU, Banaras Hindu University, where the university as well as true and first inventor, both they become the applicant. In that case, royalty is divided. For example, 20% will take inventor, 20% will take university, and 30% will go to the lab, some 10% will go to some other person. So you have in here, since legality is involved, so you have to check out who is the applicant, who is the true and the first inventor. Now comes the next thing, that is transfer of technology. Why we need to transfer this technology? Why we need here technology does not mean the technical things only. It might be knowledge. Why do we need to transfer it? There are number of things. So first we'll see what does technology transfer means. It means that transfer of knowledge, transfer of technology from one entity to another entity. In our cases, what will it mean? It will mean that if I have done some kind of invention in my lab, in the lab of GDC Baramulla, now I don't have much funding, I don't have much market research. Since I want my product to be in the market, I will have to transfer my technology to some other relevant stakeholder. But in that case, you must have technology transfer team, which will act as a mediator, which will see that you will get benefited because it's your invention. For example, in case of pharmaceutical industries, I did some kind of research in my lab. I found a new lead compound which may act as a drug. So I did in vitro activity, I did in vivo activity, and after that my research is complete, my project is complete. I don't bother. I filed a patent application. Now I don't bother. Now in that case, what you will do in case of technology transfer? This technology will be transferred from your lab to R&D, for example, to Ranbaxy, for example, to Pfizer, for example, to Novartis, and they will take it from there, and you will get the royalty. So it will benefit you, it will benefit your college, university, it will benefit public at large, and ultimately it will make our country developed country. So we have to bridge science with the market. We have to set up these things in our colleges, in our universities, so that we can take this research forward. So why do we need technology transfer? Because manufacturing capacity, lack of manufacturing capacity. We are doing research at a smaller level. We don't scale up the things. So manufacturing capacity is low. We need to transfer it to some other stakeholder who can take it from there, and we get the money, royalty, and name and fame although. So lack of resources. Usually funding khatam ho gayi, then research stopped. Now you have to give it to some other stakeholder. Marketing, we don't know how to market your things. You don't know how to distribute your thing, your invention. So in that case, you need technology transfer. For example, I have taken some few examples. Aluminium, in 1854, it was discovered. It took 100 years. In 1950, aluminium-based utensils came into the market. 100 years it took from its discovery for its utility, just because technology transfer, there was a problem. Similarly, total reflection, TIR, fiber optics बनते कम से कम 90 साल लग गए fiber optics में इस principle को लाने में. Similarly, theory of lasing, that was given by Einstein. First prototype gas laser that was discovered in 1950. For example, X-ray. This was immediately in 1895, it was discovered, and in 1900s, it was used in the medical profession. So this is the actual why we need technology transfer. This is our science, which we do in our labs. This is the product, and there is a valley of death. We call it valley of death. So what will happen? You will start your research, basic technology research. You will start with a boom, and then what will happen? You will complete your PhD. Funding is over, or you will not file an intellectual property protection. It will come to the public. Anybody can use it. Actually, nobody uses it because nobody will get benefit out of it if it is not protected by the IP. It will go to the value of death. And then if we have here, technology transfer will come into the play. If you have a team of technology transfer, this value of death, there will be no value of death. It will straight away go to the next stakeholder, which will scale up, which will make a business model, which will do the wide this. So what are the factors that cause the value of death? Maybe research complete ho gaya, to value of death uste chhod diya, then guide says chalo naya topic start karte hain, or we do not file an intellectual property. My guide usually told me that ke बहुत सारे compounds, I'll quote him, बहुत सारे compounds जो एक potential drug बन सकते थे, लेकिन वो मर गए research papers में. क्यों? Because the inventor did not file the patent. If you do not file a patent, nobody is going to touch that drug. क्योंकि clinical trial करते करते ही उसमें you have to pump millions of dollars. कल को अगर वो drug बन भी गया, it is not protected by the intellectual patent. Anybody can use it. Then when anybody can use it, there is no monopoly. Why a company ABC will put their money into that? So these are the main factors जिससे value of death बन जाती है. And in our case, lighter mode, on the lighter mode, value of death is because of the transfers as well. You get the project, you are in the college, and all of a sudden you get transferred from that college, and everything stops there, and research भी गया, आप next जगह पहुंच गए, और सारा काम वहीं पे रुक गया. So these are few examples of technology transfer. For example, BARC, Baba Atomics Research Center, they are developing technologies and being transferred technologies to the stakeholders. Around 90 technologies are being invented, innovated, and then transferred to the other stakeholders. Similarly, National Chemical Laboratories, Pune, they are into this business. IIM Jammu, they are taking, they are extracting compounds, national compounds from the plants, and then they sell these compounds to the Merck, to the different chemical companies. Eli Lilly, DBT, they're already into this business. CSIR is already into this business. ICAR, they have almost transferred 150 technologies, which includes different kinds of seeds, plant material, plant health management, to almost 350 clients. And in 2008-2015, they have generated around 6.22 crore rupees from this. Similarly, IARI, they have already made 2 different departments which bridge this death valley, and they have already given 31 different type of seeds, 14 biofertilizers, 7 agricultural chemical these technologies to the different stakeholders. So I'll conclude my presentation with this, that we have to invent, we have to innovate, and then there must be an IPR cell within your college, within your university, who is going to file this, who is going to advise you first, and then file your patent application or whatever. It may be a copyright, it may be a GI tag, it may be a trademark. And then you have to protect your invention by relevant intellectual property, relevant one. Then there should be a technology transfer team, which is going to fill up that death value of death. Or the best thing would have been if the project that you get granted, it should have been with taking consent with the private industries. That will mitigate your value of death. And there should be appropriate licensing, or there what you call that when the technology has been transferred, your rights should be taken into the consideration. With this, I take your lead, and thank you. Thanks a lot. I'll be happy to answer your questions if there's a...
Thank you very much, Dr. Uwais. It was indeed a wonderful talk. And I believe that our listeners would have really benefited from it. You talked about patents, you talked about GIs, you talked about what is and is not patentable. You talked about the legal implications, the national and international laws, and you talked about a very important thing that that the our colleges and universities need IPRs and technology transfer support and all those things. Thank you very much. I would like our participants to please if anybody has a question, please they can ask the question to our expert. They can even do it in the chat box, so I can then transfer it to them. The person.
Very informative talk.
Thank you.
I am Irfanullah from GDC Sogam. So I want to know what are the financial implications of getting to the patent. Suppose I have a data and I want to get it patented. So what in J&K situation, where should we start? So where the ball should start rolling so that I get a patent in the end.
See, it will depend upon who is the applicant. If you are the applicant, that is a national entity, there will be a fee of 1,600, I guess. However, if your college or university is the applicant and you are the inventor, in that case, the fee will start from the 10,000 rupees. It will depend upon who is the applicant. In your case, if you are the applicant, you are a national entity, it will be 1,600 rupees. The main thing actually is the drafting. Who will draft the patent application? That's the main thing. Because when you go out to a law firm for drafting a patent application, they'll charge you 50, 60, 80,000 rupees to draft a patent application.
So if I give it some private organization to file it for me, so how much they will cost me, for example?
It will depend upon who is filing it. It won't be around. It won't be less than, I guess, 20,000-30,000 rupees.
Okay, so I have one last question. Can we patent the teaching methods? Suppose I am doing something in my lab with my students and I invent some experiment which makes students very curious, and that is not published. That is nowhere. We have just done it. I can publish it, but I want to patent it. Can we do it?
No, if it is published, you cannot patent it. If it is already published, even you have published it. If you have not disclosed that experiment, then you can patent
it. I'm saying that it is not published, right?
Yeah. In that case, in that case, if it is if it's going by the patent law, then you can file a patent application for that.
Okay. Okay. Thank you. Thank you very much.
Thank you.
Hello. Assalamu alaikum, everyone. Hello.
Walaikum salam.
This is Alia Akhtar from the Department of Psychology. First of all, this is my second time to hear you, sir, about the IPR. Sir, I have a question. Suppose from your this whole presentation, I got this message that if suppose somebody is and he has copyrighted it, he has his own copyrights, and now suppose we cannot translate it unless he is permitted to do so from the original writer. Sir, if suppose someone is being reviewed by B, suppose B is reviewing the book, and then publishing the review of the book, what about that? Isn't it infringement, or is it fair to use like this? Is it come under the fair use?
Actually, your voice was breaking. I could understand that you want to know that if the book is already published and you are reviewing that book.
Suppose, yes, if I am reviewing someone's book, suppose yours book, I am reviewing it, and then I am publishing the review of that.
In that case, I have to know about what you are reviewing, and you are giving review of that book. I don't think you will infringe the copyright, but still it will have. In that case, I have to check what kind of review you are doing. If it is a general review, I don't think you will infringe copyright.
Okay, thank you.
if anybody else has any other question, you can also write your questions in the chat box, and I could, then hand them over to our guest speaker.
Sir, how to know a product is patented?
By doing prior art search. There is a prior art search, we call it as freedom to operate. Freedom to operate. In that case, you check whether that invention is already being patented. It's not necessary it is being patented. You have to check if it is anywhere documented. You have to check everything.
Sir, if we add a existing product at new features, can we patent it?
If it is, if by adding those new features, it becomes novel, it obviously it will become novel. There is no question in novelty. But if it is, it becomes non-obvious, and there is a technical advancement. In that case, it will be patentable.
Okay, sir. Thank you.
Okay, there is a question in this. The question is cyber squatting included in IPR?
Cyber?
Squatting, SQUATTING.
No, I don't think so. No, it's
Thank you,
not.
If anybody else has some questions, please do
Here,
ask.
I would like to add one thing. See, when you go on the Facebook, our generation doesn't use it much in that way, but our next generation, they are using Facebook, and then they put some songs in their reels, and they get strikes from the Facebook because that song is copyrighted material. In that case, you infringe the copyright.
I think we also infringe the copyright also, sir, when we do one thing, when we say, for example, take a long quote from a book, recently published book, and then publish that quote on Facebook or Twitter.
There is one question I can see from this: are trademarks and service marks same? Service mark is one of the trademark. It is a type of trademark.
Okay, if anybody else has some questions, I hope we're done with the questions. Just a second, nobody is replying. Okay, if Professor Rizwan Saab is around, so we can go for the formal vote of thanks. Okay. No, he's not.
Yes.
So he's
Yes,
here?
yes, the answer is there, yes.
Please, Rizwan Saab.
Thank you very much, Mahisab. Thank you. I would like to thank Dr. Saeed Uwais, Assistant Professor, J&K Higher Education Department, for sharing his valuable time and knowledge with the participants and joining us for this webinar in a short span of time. I would like to thank him for his guidance regarding the intellectual property rights. I would like to thank Principal Secretary, J&K Higher Education Department, Special Secretary, J&K Higher Education Department, Director Colleges for their patronage, guidance in the organization. I'm also thankful to the Nodal Principal, Professor Dr. Sheikh Ijaz Bashir, for his encouragement. This webinar series would not have been possible without the guidance and support of our worthy principal, Professor Dr. Mohammad Farooq Rathar Sahab. Thank you for your personal interest and guiding us all and coordinating this webinar series. We are also thankful to Professor Tariq Ahmed Chalku Sahab, our HOD Physics, and for his pivotal role and guidance. And I would like to thank IQAC team and the coordinator, Dr. Mutahar, for playing such a pivotal role in this for organizing this webinar series and involving different aspects of life, such as technology, academics, industry, literature, and whatnot. Thank you very much. That would be for me.
Thank you very much. Thank you, everybody. So we're signing it off. Thank you very much.
Thank you.
We'll request the participants to open their cameras for a photograph, a group photograph. Kindly open your cameras. Keep them open for 1 minute maybe. Thank you. And once again, on behalf of the Internal Quality Assurance Cell, GDC Baramulla, I'm thankful to Dr. Wes for sparing his valuable time with us. We'll look forward to more collaboration in future. Thank you very much, sir.
Thank you, sir.
Also thankful to all the participants for making this webinar series a success. Thank you very much for your continued participation. Okay, so we'll be ending the session now. Thank you very much. Thank you, Humayun sir. Thank you.
Thank you.